are a very, very dangerous person. And I'm going to tell you, what does this look of bewilderment? You're charged with aggravated robbery. You're charged with retaliation. And now you pick up 2 other cases. I'm going to do everything in my power to protect the public. And I'm going to tell you now, if that means having to stick your bonds at $50,000, I will do it in a heartbeat. I'm going to put a whole host of conditions on you. I don't know if you're going to get out, but if you do, you violate one small thing, you will be staying with me. Do you understand? No dope, no alcohol, no going to any of the places where you've been charged with theft or any of the other things that you got, no weapons, and I'm putting an ankle monitor and I'm giving you a curfew. I don't want you out in the middle of the night. Your curfew is from 9 p.m. to 6 a.m. Do you understand? Your bonds now are set at around what, 70? Who's representing?
Shreya's representative.
Yeah,
Oh, no,
Josh.
Josh, he stepped out because it was just coming out to sign the
Oh, I
condition.
can step in.
No, I think his bonds are wholly insufficient. His criminal mischief is at 1,000. His theft is at $800. That's just, and he's charged with aggravated robbery and a retaliation. I don't think so. That's like, that's, yeah, I'm going to need, so what we'll do is I'm going to roll him to tomorrow and we'll talk with Josh tomorrow, but I now find that your bonds are wholly insufficient. You're way too dangerous, man. Way too dangerous.
You need to wait on the bond conditions then?
No, let's have it signed just in case he makes bond now. That way we have it in place. But I'll readdress the bond tomorrow. Perception is reality. So you're wanted out of Kern, California for willful cruelty to a child. Are you waiting formal extradition, sir?
Yes, sir.
Okay, so what that means is we give the demanding jurisdiction here, California, 2 weeks to come pick you up. And if they fail to come pick you up within that time, we will release you.
Yes, sir.
You know that California is ready to come get him? Amy?
Oh, yes.
Okay. All right. Good luck.
Thank you, sir.
Thank you, Judge.
Go ahead.
So let me get this right, Josh. He was out on bond for the aggravated robbery. He was out on bond on the other case on the retaliation, and then he picked up these 2 new cases, right? Is that right?
Let me check that.
I think he was out on bond for the ag rob, and then,
Oh, the
Picked up.
ag loss from May.
yes. And then picked up
Picked up a
the theft.
retaliation on 9/4. And then after that, so it's a 3rd time he's out, and then he picks up another case?
These allegations, Judge, are from August of this year, the 2 cases in this court.
Yes.
Let me see.
It was after the ag rob and before the retaliation.
All right, so the retaliation is September 3rd. Mischief is August 28th. That is August 8th, 28th as well.
So I found that I had one. Got myself there.
Okay, so let's talk about this. So officers get a call that a robbery has occurred. Complainant stated to officers two defendants later identified as Defendant Marshall and Defendant Ronald Waters, which was our other defendant from the other day, right? Remember Ronald Waters from yesterday? Hereinafter referred to as Waters and Marshall walked into a store, destroyed a glass partition which was $300 to replace, and walked out of the store with 3 vapes and other stuff, sodas and complainant stated both defendants walked in at the same time. Waters came up to the counter stating he wanted to purchase a t-shirt located behind the counter. While that was happening, Marshall attempted to come behind the counter, but the complainant was able to stop him. He reported that Marshall then came around to the front of the counter where Waters was, that he was distracted by Waters, who purchased a t-shirt, opened the packaged shirt, and seconds later wanted a refund, which he gave him the refund. Complainant reported that as that was happening, Marshall used his hands to...
Okay, pause. This is where it gets dark. The prosecutor's about to read the facts of the aggravated robbery. And spoiler, it involves a Domino's delivery driver, a gun that clicked but didn't fire, and a fanny pack theft. But here's the legal twist. Marshall wasn't the one holding the gun. He was the getaway guy. In Texas, that's still aggravated robbery under the law of parties. You don't have to pull the trigger. You just have to be there, helping. That's a life sentence kind of assist. Keep watching, because the ending of this story is brutal.
Mess with the glass partition, heard the glass breaking, grabbed 3 vape pens, other things, and ran out the store without any attempt to pay. Complainant states that he knows both defendants by sight and can identify them from priors. So while being out on all that, on the aggravated robbery, in that one, what do we have? Did he hold someone up?
Background.
Yeah, let's see how dangerous Mr. Marshall really is. Allegedly.
So the complaining witness was a delivery man for Domino's. I believe he made a delivery to the co-defendant in that case. The complaining witness said he felt something wasn't right and told the co-defendant to just pay him half so he could leave. The co-defendant pulled out a handgun, pointed it at the complaining witness, and demanded the pizza. The complaining witness noticed this defendant by his vehicle at that point and observed defendant Marshall open his front passenger door, reach in and steal a fanny pack that held his cell phone. So this defendant
Part of
was,
the offense. He's not the one with the actual.
he was not the one pointing the gun, yes, Judge.
The complainant began to feel that something was not right and offered to accept half the amount due for the pizza just so that he could leave the location. White then pulled out a firearm, pointed at the complainant, and demanded the pizza. White told complainant that he had 5 seconds to give him everything he had and began to count out loud. Do you know how scary that is to have someone hold a gun at you, tell them you have 5 seconds to give them everything or else? That is really, really terrifying and can cause people to have nightmares, all kinds of psychological issues. God. When defendant White reached his 5-second countdown, the complainant stated that he saw defendant White attempting to pull the trigger and could hear a clicking sound. It was at that moment the complainant was fearing for his life. He attempted to push defendant White's pistol away from his face and was able to retrieve his own firearm, namely a pistol. Complainant feared for his life and discharged the pistol at defendant White. Oh, the complainant shot and killed defendant White, who died at the scene. Complainant stated the defendant Marshall ran off with his property and the complainant drove to a safe location before calling the police. This is Houston. I will do everything in my power to protect our city. And I want you to understand that. And that person is now gone. For a pizza, his life is now gone. How well did you know this person? How well did you, was he a good friend of yours?
Someone I knew in the apartments.
I'm going to make each of your bonds $3,500. Mr. Marshall, I want you to understand that if you are able to make bond, I'm putting a whole host of conditions on you.
So I will understand.
Don't be a danger to our city. You have but one life. Stop. You have but one life. You know, when it's gone forever. And it's so very, very short. So heed the advice, because I'm not giving you any more warnings. Do you understand? Okay.
Let that sink in. The delivery driver, the victim, pulled his own gun and killed the other defendant, White. Self-defense? Almost certainly. But here's what's haunting. Marshall ran off with the driver's fanny pack while a man lay dying. And Judge Fleischer knows it. That "you have but one life" speech? That's not just advice. That's a judge looking at a young man and saying, "I've seen your future, and it's a body bag or a prison cell." Question for you. Should Marshall have gotten more than $3,500 bond for being an accessory to a fatal robbery? Yes or no?
Thanks, Steve. Thank you. Good morning, Mr. Jones.
Good morning.
Mr. Jones, you were wanted out of the state of wherever. Probably denial, I don't know. But I have you here now because your lawyer is asking me to set you a bond.
Yes, sir.
I don't know. I've never met you before. I don't know who you
Order in the
are.
court.
No, my primary concern are two things. Number one, will you go back to the jurisdiction that you wanted from? Number one.
Yes, sir.
More importantly, and most importantly, are you a danger to the community? I know that you're going to tell me that you're not. Everyone says that, right? But what really dictates is how you look on paper, because that tells me who you really are. So I just don't know. We'll go through all that and we'll determine whether, you know, I do know that you have an open evading arrest in a motor vehicle. So you're now charged with a 3rd-degree felony. And so, all right, Amy, tell me about it.
Yeah, he's wanted from St. Lucie County in Florida.
Oh, Florida. Oh,
Yeah.
Ouch.
He's wanted for a violation of probation for a grand theft of a motor vehicle. We're asking for no bond at this time. For one thing, he picked up this evading of a motor vehicle while on that probation. He has, and
Is this a stolen car too? Allegedly.
I don't think he was charged with that, Judge, so I would say,
Yeah, I mean,
a prohibited vehicle on the toll.
but we had an earlier case today, same thing, in a stolen car, right? Allegedly, and they didn't charge him with the UUV, but they could have.
okay.
So it's intake, I don't know, just these days, it's,
I'm seeing prohibited vehicle on the toll. That's
so
all.
it is a prohibited vehicle?
On the toll.
So
I don't know.
a
What-
prohibited vehicle could be a vehicle that
Yeah, it's
has
very,
outstanding
very vague.
balance. That's exactly right. Or no tags or.
What other kind of criminal history he got?
Yeah, he has, an obscene number of fraud and forgery charges out of Florida and Georgia.
How many?
22 pages worth.
22 pages worth of criminal history?
Yes, he also has
Whoa!
several failure to appears out of Florida. He was arrested in May 3rd of 2023 for a probation violation in Florida. Of course, this probation violation is for 3 different violations for failure to report and then changing address without permission, I think.
22 pages of priors.
Well, I would say this, Judge, sometimes the one case can take up to 2 pages sometimes, so
Even by that theory.
even, I get cheaper.
He also has misdemeanor and felony willful obstruction of law enforcement officers out of Georgia.
I'm surprised you even got probation. You know, I mean, really, it's, you know,
All the charges were trickled down to 2 counts. So there was, all those charges are the exact same charge, and they dropped it to,
22 pages worth of the exact same charge?
it was 19 charges. And they brought it down to 2. They was basically 2 charges, 2 different kind of charges, but 9 charges of each. So
It happened that would garner 19 charges. That's usually something where you have like a mass event, like a shooting or like,
no, it wasn't nothing like that.
The probation violation's original charge, which was a grand theft of a motor vehicle, he obtained that motor vehicle by,
like false
Buying it.
pretenses or something.
yeah, he tried to buy it with a false pay stub for a false company.
Judge, if I may,
Sure.
Judge, I'm not asking for a PR bond. I'm asking for, even if you consider a bond, a high bond amount that would allow him to go turn himself in. He would have skin in the game. It's a monetary sum that would ensure that he goes and turns himself in. He hasn't messed up in your court before.
Seen.
I'm sorry. And so it would allow him to at least go present himself while also understanding the risk of losing a big deal of money. So I'd say that
Whose money? Not his money. What kind of money you got?
No doubt.
Doing what?
Over detail.
I'd like to afford him the opportunity to get a post that bond,
Uh,
if you entertain.
Well, the
giving him.
first thing I'd need to know is, out of the 22 pages, what are all those, I'd like a list of like every single charge that he's ever had.
Okay.
I'd like to know the disposition of those charges,
Okay.
because, you know, the problem is, Mr. Jones, is that when you have too much baggage, the more baggage you have, the higher of a flight risk you are, because you know that at some point you're going to have to answer to those charges, and you're going to try to.
But I answered to all those charges.
Well, I don't know that. I know you're telling me that,
I
but
understand, but those, I handled that. That was my first real
22 pages. Let me repeat that. 22 pages of criminal history. For context, most people's rap sheets fit on 1 page. 2 if they're really busy. 22 pages means this man has been in and out of courtrooms more than a bailiff has had hot coffee. And Judge Fleischer just dropped the line of the day. The more baggage you have, the higher the flight risk. That's not opinion, that's actuarial. Statistically, if you've failed to appear before, you'll do it again. So here's my question. At what point does presumed innocent lose to proven pattern? Heavy stuff. Stick around.
the case, and I handled it.
yeah, I mean,
And
I
some
mean-
of those with like with the FTA and stuff, I turned myself in. It was misunderstandings with court dates and stuff like that. And it'll show where I turned myself in like multiple times.
In this case here, you're trying to evade capture here. I mean, so I don't know. You know, I need to know a lot more about you before I were to grant you a bond, you know?
Like the current case, I can't speak on that right now. But
Don't, right, don't.
all the other cases, I turned myself in and I handled what I needed to handle.
You know, has he ever had a prior fugitive case before? Out of where? So Ricardo, if you want, we can do a deeper dive, or you guys can do a deeper dive and let me know more about him.
Here's the thing, Judge, I don't think it's, here's how this, it would work. I don't have access to the 22 pages. I would love to give you the report by tomorrow. I could do that.
So
I
what
just
we can
don't
do
have
is
those.
we can ask Amy to print you out the NCIC report. Can you provide him with a copy?
I'd have to ask Dave, if that's all right with you, Judge.
They're, at least at the minimum, I know that they'll let you look at the report. So you can
Right.
look at it and write it down. I don't know if they'll give you a copy of it, but at least you can look at it and we can try to work through to see all the charges of what they are,
Right.
try to find out what the disposition, but,
I can also go through it and.
right.
Okay.
But with 22 pages of prior criminal history, I'm going to tell you now, it's a really uphill battle to give you a bond. And if I do give you a bond, it's going to be a hell of a high amount now. In the high five digits, perhaps 6 digits, because no, I want to make sure that you turn yourself in. And the problem is that I know that there's a hurricane out there hitting Florida. So it's a perfect time for you to give me this kind of excuse there. I couldn't make it there. I couldn't make it here because of this and that. And when here,
Okay, I'll explain some of his options, Judge. We'll go over where we're at and, I'll see how he wants to proceed.
okay, but I'm going to tell you now, if I were to give you a bond, it's going to be in the high 5 digits.
Understood. Judge, my understanding is he already waived on, October 8th, and so his, pickup date's the
You know
23rd.
what? And I'm going to tell you now, we have at least 3 other people here from Florida. And I think it's Miami-Dade, right? Wasn't it Miami-Dade that we have?
Yes, this one is St. Lucie County.
How far is that from Miami-Dade? So perhaps we can come get them to pick you up in addition to those 2, because I know that we have at least 2 transports that are coming here to pick up another 3 individuals from Florida. So maybe we can get you on that, and they're supposed to be here next week. You know, so if you waive, or like, I mean, you've already waived,
Already waived.
so great. So
I'm not trying to run from nothing. I just want to get this over with.
here's the only other advice I'm going to give you now, is that you need, if you do go back, you have to stay in contact with your felony lawyer in your felony case, because if you don't, and they think that you've absconded, they're going to issue a warrant in that case. And then the hold that you have here for your Florida stuff, it's going to happen to you over here, because you're going to be over there, and then you're going to get a Harris County hold. So when you do finish up over there, you're not going to get out, and they're going to try to transport you back over here. That is Eileen Bogart is your lawyer over there. So just stay in touch with her to let her know what's going on, and that way they don't overlook you. Okay?
Thank you, Judge.
Of course.
I'll talk to my client.
Thanks. Can you let Day know that perhaps we can get them on the train of transport? Morning, Mr. Houlihan.
More.
How's jail?
Sucks.
Good. Wonderful.
Definitely, don't ever want to come back here.
The worse of an experience you have, the higher likelihood you have of truly listening and realizing that we mean business, because that's what we do. When we when we tell you not to do something, it's not for shits and giggles, it's for the real deal, and you're not supposed to. And when you do, there are serious consequences. And coming in here and tell me it's NyQuil or this, I don't care. No alcohol means no alcohol from any source. Now, at the same time, I don't want you to plead guilty just to get out, right? Because that's what you were going to do, and that's what everybody does just to get out, and I don't want that to happen. I'm going to give you another chance today. I'm going to put a monitor on your ankle so that I know that you're not consuming alcohol. And I'm going to tell you now, I will never play this game again with you.
Yes, sir.
So the next time you consume alcohol, and I don't care what source it is, and you've got your mom here to know, whatever it is, I don't care if it's the tequila lollipop, hair dye, you had dinner with Mother Teresa, whatever. The next time you consume, you will be with me. And you know now You have no one to bond you out. So you're going to sit there.
Did he just say tequila lollipop and hair dye? Yes. Yes, he did. Judge Fleischer is famous for these lists because he's seen every excuse. I didn't know mouthwash had alcohol. It was vanilla extract. My grandma's apple pie fermented. The ankle monitor he's describing tests perspiration. It's called a scram monitor, and it does not care about your excuses. But here's the real wisdom. He's waiving the $500 monthly fee, so there's no excuse. That's a judge who actually wants rehabilitation, not revenue. Respect. But seriously, apples turning into alcohol? That's a real thing. Don't eat overripe fruit on scram.
For who knows how long. Do you understand?
Yes, sir.
No alcohol whatsoever.
Yes, sir.
The monitor that I'm going to put on you costs around $400 to $500 a month. I'm going to waive that fee for you so that there's no excuse. You need to charge that thing on a daily basis. So if the battery goes dead, so do you. You must charge it on a daily basis. Be careful for whatever you put in your body because that machine is extremely finicky. It tests alcohol through your perspiration. So whatever you're eating, be careful. Apples, what happens to apples? What happens to bananas? They can become alcohol at some point. So you need to be careful. Apples, some fruit ferments. So just take that with what it is. Be careful whatever you put in your body.
Yes,
Are there
sir.
instructions somewhere that?
Yeah, they will advise him when he gets the monitor. They'll advise him on what he can and can't do, but it's also common sense. You have to know everything that you put in your body. If you're going to go to a party and there's a bucket of punch there, probably not a good idea to drink the punch, right?
Yes, sir.
Okay. Just use common sense.
Yes, sir.
It's not that hard, and be nice to people.
I definitely learned
I'm letting you out now.
I don't want to end up being like my father.
That right there gives you pause to concern. I mean, you're headed there. I mean, you're in jail. You're headed there. I mean, if there's no other wake-up call, then this is the wake-up call. Don't end up like that. You have the opportunity now to apply for a diversion program that if you get in, which you probably will if you do the application correctly, if you complete it successfully, they'll dismiss this case against you. It's a really big deal because when you get a DWI on your record, it closes so many doors, not to mention your life. It's going to cost more in every respect. So just be good. All right. Yeah, drug testing as well. You're going to be tested 40 days from today. If you find weed in your system in 40 days, that tells me that you've continued to smoke weed. I'm going to put you in jail. Don't smoke weed. Don't go to any parties. Don't hang out with anyone that you think that they're going to use because peer pressure sucks. And it's very, very difficult. So if you're hanging out with the wrong people, they're going to take you down. No dope, no alcohol. You'll be tested in 40 days. And you know now what that machine does. Do you have any questions? Okay. Listen to Mr. D, and then we'll see you in a couple weeks. Thanks for coming, man. Do you have any questions?
No.
I'm going to set up.
Remember, be patient with Mr. Dixon. He has so many cases. I mean, you see, he's running from court to court to court to court. He's like Speedy Gonzalez. So just take care, understand he has a lot of cases, and that if you call him, at some point he'll get to you. And
I'll meet with him in my office this Sunday.
And if you can always come here and meet here as well. We're always happy to have you at any time as well. Okay? All right, guys. All right. Good luck, Mr. Houlihan.
All right, sir. This way for me. Thank you, Your Honor.
Thank you, Mr. Dixon.
Judge, for clarification, 40 days for